Welcome to the Fort Lee Office of the Staff Judge Advocate Client Services Division. This briefing is an overview of separation and divorce. It is intended to address the most commonly asked questions and to provide a basic understanding of the fundamentals of family law. The brief is for informational purposes only and should not be considered an adequate substitute for seeking legal advice from an attorney. Viewing this briefing does not create an attorney-client relationship between the viewer and any member of the Client Services Division. If, after viewing this brief, you have specific questions or legal issues you would like to discuss with an attorney, we will be glad to make an appointment for you. Our office has informational handouts on many of the topics discussed in this briefing. These handouts are available in the briefing room or in the informational kiosk in the reception area. The separation and divorce process can be very stressful and often confusing. We hope this brief will give you basic information that will allow you to make informed decisions during this challenging time. When can I file for divorce? Where do I file? How long does it take? These are the most frequently asked questions our clients have about divorce. We'll answer these questions first, then move on to address other important issues.
So, when can you file for divorce? Most states require a minimum period of separation before the court will grant a divorce. The separation period can be as little as 1 month or up to 1 year or more. It depends on which state you file in. Here are a few examples. Virginia requires a 1-year separation if the couple has minor children together or if the wife is pregnant. If there are no minor children and the parties have both signed a separation agreement, the separation time is 6 months. North Carolina has a 1-year separation requirement, even if the couple has no children. In Texas, the required separation period is 60 days, but no divorce will be granted during pregnancy. The separation period in Florida is only 30 days as long as the parties are in agreement on the terms of the divorce, the wife is not pregnant, and there are few assets. In California, you can file for divorce as soon as you want, but have to wait 6 months before the court will grant it. In New York, there is a 1-year separation period. For more information about timing in other states, you can search online or make an appointment to discuss your case with a legal assistance attorney. Where you file depends on your spouse's residency or your residency. You can file where you live or where your spouse lives. In certain circumstances, you can file in the service member's home of record. Residency requirements vary by state. Most states require you to live in the jurisdiction for the 6 months immediately before filing for divorce, but you will need to consult the rules for the specific state where you intend to file.
While waiting to file for divorce, there are things you can do to make the process quicker and be less expensive. If you know you are headed to divorce, you likely want to settle as many matters from the marriage as possible. You can wait and ask the court to settle all matters such as support, custody, property, and debt division. But having the court make those decisions will be time-consuming and costly. You and your spouse can come to an agreement on these matters. You and your spouse can enter into a separation agreement that wraps up all matters from the marriage. The key is whether or not you can actually come to an agreement. It will likely be a negotiation between you and your spouse. You may not get everything you want, but may decide it is worth it to not have to go to court. If you and your spouse cannot agree, a separation agreement is unlikely. In that case, the court will decide how to settle matters like child custody, child support, and spousal support. You can petition the court for temporary custody or support. The temporary order will remain in effect until the divorce court takes final action. You may also take advantage of the Army rules that require a soldier to provide support to his or her dependents when there is no separation agreement or court order. Hopefully, you and your spouse can come up with a separation agreement so you won't have to fight in court. A separation agreement is a contract between you and your spouse detailing your rights and responsibilities during separation and divorce. A separation agreement can simplify the divorce process by asking the court to incorporate the terms of the separation agreement into the divorce order. The separation agreement can settle all matters relating to the marriage. You can always ask the court to make changes about custody, visitation, and child support if circumstances change in the future.
In most states, there are two types of child custody. Most of the time, both parents will retain legal custody. Legal custody defines who can make important decisions about the child, including education, health care, child care, and religion. Legal custody is usually joint unless one parent is unfit. For example, if one parent is in prison or has had their parental rights terminated. Physical custody refers to whom the child lives with. Shared physical custody, 50-50 shared time, is not practical unless the parties live close to each other. Most often, the child lives primarily with one parent and has visitation with the other parent. The parent the child lives with more of the time is referred to as the custodial parent. In the separation agreement, parents can agree on which parent will have physical custody. You can also agree about when and how often the child will visit the other parent. When determining visitation arrangements, there are several things to consider. Frequently, people want flexible visitation, where the child can spend as much time as possible with the other parent without having a set schedule. While this option is attractive, it is usually not practical. Flexible visitation works best when the parents are on good terms and live close to one another. But circumstances can quickly change and make flexible visitation unworkable. Can you still be flexible with visitation when one party relocates? Will you still work together when your ex-spouse gets remarried and has a new family? If these complications come up, you may have to go to court to amend the visitation arrangements. This can be costly and time-consuming. It is much better to set out a specific visitation provision in your separation agreement. A visitation schedule in the separation agreement will guarantee a minimum amount of visitation a parent can have. You and your spouse can still be flexible with visitation. If parents agree, the child can visit at any time. But if they don't, the specific visitation schedule will control. A visitation schedule also gives both parents a certain amount of predictability. For instance, if the separation agreement dictates which parent has the child for Christmas, each parent can plan ahead and know they won't have to negotiate for visitation. A visitation schedule can be as specific as the parents want. The visitation schedule can outline the specific weekdays or weekends of the month the child will visit the other parent. The visitation schedule also allows the parties to make provisions for visitation during breaks from school, like spring break or summer vacation. The separation agreement can also address travel arrangements for long-distance visitation. For instance, who pays for the travel? How will the child travel? Do the parents meet halfway? Specifically addressing these visitation issues in the separation agreement can avoid problems later. Service members have special visitation considerations. Deployment does not give the other parent the right to change an existing agreement or court order. What happens if the service member isn't available during his or her specified visitation because of military duties, for example, being in the field or unable to take leave? Exercising visitation rights is optional with the parent who has it. If that parent is unable to visit the child as scheduled, it does not impact or reduce their right to future visitation. The other parent may be willing to work out an alternative visitation schedule to make up for the missed time, but will be under no obligation to do so. Service members should consider how to handle childcare during extended visitation times. Regardless of what your visitation schedule is, if your separation agreement addresses custody, it should also address child support.
Child support is meant to provide for the child's basic necessities, including food, clothing, and shelter. Every state has its own calculations for determining child support. We will look at the child support guidelines for Virginia on the next slide. Parents can agree to a child support amount in their separation agreement. Parents planning to divorce in Virginia should determine the amount required under the Virginia guidelines. The parents can agree to any amount, but if it is too low, a Virginia judge may reject the amount at the time of divorce and order a child support review. If the parents cannot agree on a child support amount, the court can decide in Virginia. Either parent, but usually the one who the child lives with, can go to the Department of Child Support Enforcement Services to have them file for child support on your behalf. Or either parent can schedule an appointment with an intake officer at the local General District Court Services Unit office. The intake officer can help you fill out the paperwork so you represent yourself in court and ask a judge for child support. The final option is to hire a private attorney. In Virginia, child support is calculated based on the gross income of both of the parents, the number of minor children being supported, and the amount of time the children are with each parent throughout the year. Gross income includes money from all sources, including BAH and other military allowances. You can find the Virginia Child Support Guidelines online and even access a form that will automatically calculate suggested child support amounts based on the information you enter. The Virginia Child Support calculation will also consider payments made for health care premiums and child care expenses paid by either spouse. Military health care coverage will not be a deduction in this case because there is no monetary value attributed to this coverage. Child support may also be reduced when a parent is already paying child support for other children or pays support to a former spouse. Virginia requires child support to continue until the child turns 18. That age is extended to 19 years old if the child is still in high school. Parents may voluntarily provide that child support will continue past high school in the separation agreement. If a child is severely and permanently disabled, Virginia will require child support to continue as long as the child continues to live at home with one of the parents and is unable to live independently. It is a good idea to include a provision in the separation agreement or divorce pleadings that requires the parent paying child support to have a certain amount of life insurance naming the other parent and minor child as irrevocable beneficiaries. The proceeds from the insurance policy can cover future child support if the parent paying it dies before the child turns 18.
A couple can agree on spousal support or alimony in their separation agreement. You can decide the amount and how long it will be paid. If you cannot agree, a judge may award it anyway. Every state has different factors to consider when determining spousal support eligibility. In Virginia, you are eligible for spousal support only in certain circumstances. It can be difficult to get from a Virginia court. If you must go to court to ask for spousal support, you are strongly encouraged to hire an attorney to help you because it is not easy. If you are seeking spousal support from a court in Virginia, you must make the request for spousal support before your divorce is granted or you give up the right to ask for it. A Virginia judge will consider many factors to determine the amount and duration of spousal support. Think about it in terms of a judge trying to make sure both of you will be able to survive and pay bills during the separation or after divorce. A judge is going to look at the length of the marriage, the earnings of each spouse during the marriage, and the earning potential of each spouse, along with the couple's standard of living during the marriage. For example, if one spouse did not work during the marriage and does not have a significant work history or a college degree, that spouse may have difficulty securing employment upon separation or divorce. A judge is going to determine the standard of living the spouse was accustomed to during the marriage and determine if he or she will be able to maintain that standard of living after separation or divorce. A judge will look at the relative incomes of the spouses. If one of you is earning $5,000 per month in the military, with bills totaling $3,500, and the other spouse finds a job earning $1,500 per month, but will have bills totaling $2,500 per month, the judge may award some amount of support to the spouse with a lesser income to help make up the shortfall while that spouse seeks further employment or education. The judge may also consider how long you were married. If the marriage has been relatively short, only a year or two, the spouse is less likely to get spousal support than someone who was married a longer time. Spousal support is very fact-specific, and the likelihood of someone receiving it will vary on a case-by-case basis. In determining whether to award spousal support, a judge may also look at the circumstances that led to divorce. For example, if one of you committed adultery, that may increase the chances of the other getting spousal support. If the spouse seeking spousal support was the one who committed the adultery, that will decrease the likelihood of that spouse receiving spousal support. Keep in mind, however, that before you can use adultery as a basis to receive or reduce spousal support, you have to prove the adultery in court. This will make the divorce more complicated and expensive.
In their separation agreement, spouses can agree on how to divide personal property, such as furniture and vehicles, and real property, such as houses and land. If you cannot agree, you can ask the court to divide your property. The more things you can agree upon, the less expensive and time-consuming your divorce will be. Items you had prior to your marriage remain your separate property, unless you have converted them to marital property. For example, if you bought a home before you got married and it is titled in your name alone and your spouse never contributed any money towards the mortgage or improvements, that home would likely be considered separate property. If your spouse did make mortgage payments or spent money to improve the home, it could have been converted into marital property. Marital property is anything acquired during marriage, regardless of who has legal title. For example, if you bought a home during your marriage, but only one of your names is on the title, that home is still marital property because it was purchased during the marriage with income earned during marriage. You and your spouse can verbally decide who is going to get which items from the home, like clothing, jewelry, furniture, household goods, etc. You do not have to list every single item in the separation agreement. If there are any assets you and your spouse own jointly, such as a home, a vehicle, or bank account, you will need to specify how they will be divided in the separation agreement. If both spouses are on a vehicle, title, or loan, you will need to decide which party will keep the vehicle and any corresponding loan. If possible, have the party keeping the vehicle refinance the loan solely into his or her name. As long as your name is on the loan, you are still liable for the payments even if your spouse keeps the vehicle. Also, once the spouse has refinanced into his or her name alone, you should take steps to remove your name from the title. This will protect you from liability as a co-owner if your ex-spouse causes an accident while driving the vehicle. Determining whether real property, for example, houses and land, is marital property can be very fact-specific. But generally, if the real property was purchased during the marriage, it will be considered marital property and must be disposed of either in the separation agreement or by the court. If both spouses' names are on the loan for a home and one spouse wants to remain in the home, the remaining spouse will need to refinance the home into his or her name. If there is equity in the home, it can be split between the spouses and could be paid to the moving spouse upon refinancing. If the house is not refinanced in one spouse's name alone, the other spouse remains liable for the mortgage, taxes, insurance, etc. If the home is paid off, the spouse remaining in the home may need to compensate the other spouse for his or her share of the equity. If the home is sold, the spouses may share the profit or loss equally unless they agree to some different division.
The pension or retirement pay earned during the marriage is considered a marital asset that can be divided at the time of divorce. This includes military retirement and other retirement plans, such as IRAs and 401ks. The presumption is that each spouse contributes to the retirement the other spouse earned during the marriage. The contributing spouse has a 1/2 or 50% interest in the other spouse's retirement earned that overlaps with the marriage, but not in retirement earned before or after the marriage. Neither party has to actually be retired at the time of divorce for the separation agreement or court to divide the retirement pay. If the separation agreement or court at the time of divorce do not divide the retired pay, its division is forfeited. Each state has its own rules for dividing retirement pay. Here is a very simple example of how a court might determine a spouse's interest in the other spouse's military retirement. If the service member spouse has a 25-year career with 10 years of marriage overlapping with that career, you would divide the number of years overlapping, 10, by the number of years of service, 25, which equals 40%. The non-service member would have a 50% interest in that 40%, which equals 20%. If the service member spouse is still serving, please note the following. The longer the career lasts, the smaller the percentage of the retired pay the other spouse will receive. The court will determine the service member's high 3 base pay on the date of divorce. The high 3 is the monthly average of the highest 3 years of base pay. This example assumes a high 3 base pay of $4,000 at the time of divorce. So $4,000 times 20% equals $800, which is the non-service member spouse's share of the retirement. Military retirement pay only includes disposable retired pay, or the amount you get from DFAS. Disposable retirement pay does not include disability retirement pay or combat-related retired pay. Retirement pay is divisible if the marriage overlapped with any period of military service. There is no minimum length of overlap required. A common misunderstanding among service members is that the marriage must overlap with at least 10 years of military service in order for the spouse to get a percentage. However, DFAS requires at least 10 years of overlap for direct payment to the non-service member former spouse. Spouses may agree to divide retirement pay in different ways. For example, the non-service member spouse may agree to a reduced percentage in return for the marital home or something else of value. Spouses may also agree to waive any rights to the other spouse's retirement plan. This waiver can be mutual. Ultimately, if spouses cannot agree on how to divide retirement pay and it has a significant value, it may be worth hiring a civilian attorney. Also consider other sources of retirement pay, like thrift savings plan and any other retirement plans.
Spouses are eligible to stay on the service member's insurance during separation until a divorce is final. When a non-service member spouse is married to a service member who served in the military for 20 years and whose marriage overlapped with 20 years of service, that spouse will keep TRICARE for life even after divorce. When there is a minimum of 15 years of overlap, but not yet 20, the non-service member spouse will keep TRICARE for 1 year after the divorce is final. Married couples often share debts from mortgages, credit cards, student loans, vehicle loans, etc. One issue involving debts is determining whether divorcing spouse's debts arose in a community property or equitable distribution state. In community property states, debts created during marriage belong to both spouses, regardless of who incurred the debt or whose name the debt is in. Debts created before the marriage in community property states are typically the sole responsibility of the spouse who incurred the debt. However, the other spouse can become a party to the debt if he or she added to the debt or paid on the debt during the marriage. In equitable distribution states, debts incurred during marriage belong to the party whose name it is in. Debts incurred before the marriage are treated the same in equitable distribution states as they are in community property states. Those debts typically belong to the spouse who incurred them. Virginia is an equitable distribution state. Despite these rules, spouses can divide debt however they want. The separation agreement should be detailed and should list the names of the creditors, the account numbers, and the amount of the debt. So what if spouses cannot agree about child support or spousal support? Is there still an obligation to support? It depends on who is seeking the support and whether the Army regulation applies or if the court is involved. Army Regulation 608-99 is the Army's dependent support provision during separation. In Virginia, the Juvenile and Domestic Relations Court can order temporary or permanent support. You can only receive support from one or the other, but not both. Note that each branch of the military has its own regulations and rules.
In the absence of a court order or agreement, AR 608-99 applies. The regulation requires service members to support their dependents by paying their non-locality BAH with dependent rate based on rank to the non-service member spouse. Dependents include the service member's current spouse and all children, whether from the current marriage or a prior relationship. Commands do not want to be involved in personal matters, but they will if a service member is not supporting his or her dependents. AR 608-99 is punitive, which means a soldier can be punished for not following it. When should you go to the Juvenile and Domestic Relations Court? 1. You're a spouse who isn't receiving spousal support. 2. You're a parent seeking child support and the child is living with you. Note that you must go before the divorce for spousal support, but can go at any time for issues involving the children, including custody, visitation, and support. Each court has intake officers at the Court Services Unit of the Juvenile and Domestic Relations Court. Call the office closest to you to see if you can walk in or need an appointment to meet with an intake officer and ask them what information you need to bring. Be prepared to provide financial records and a good address for your spouse so that he or she can be served. The intake officers help with the paperwork but do not represent people in court. Then the court holds a hearing and makes a decision based on what has been presented.
To initiate a divorce proceeding, one spouse must file a document called a complaint, asking the court for a divorce. Along with a filing fee, other documents need to be filed with the complaint. The complaint must list a reason for the divorce. The most common reason is irreconcilable differences, which means spouses are not getting along. Once the complaint is filed, the other spouse must receive notice, which is a copy of the documents that have been filed. When one spouse files for divorce, the other spouse will receive a copy of the complaint and will have a chance to respond within a certain time frame. It is very important to respond. The response is called an answer. It must be filed with the court and a copy must be given to the other spouse. The answer will depend on whether the spouses agree with the complaint. If you receive a divorce complaint from your spouse, hire an attorney or bring it to our office so one of our attorneys can review it. If the answering spouse agrees with everything in the complaint, the answer will tell the court that he or she agrees and does not plan on personally appearing in court or fighting the divorce. This is called an uncontested divorce. If a spouse disagrees, the answer should list the reasons why. In that case, the answering spouse would tell the court he or she wants continued notice in order to personally appear in court to explain why he or she disagrees with the divorce. This is called a contested divorce. Either spouse or both spouses can hire a private attorney whether a divorce is contested or uncontested. A civilian attorney will file all the court documents and help a spouse through the divorce process. This can cost thousands of dollars and can prolong divorce. But it is the best way to protect your interests if you and your spouse cannot agree to the terms of divorce. If the divorce is going to be uncontested, a spouse may be able to represent himself or herself. This is called pro se representation. How successful you will be in this pro se representation will depend on what state you are filing in. It is not easy to represent yourself in a Virginia court. The court clerks will return your paperwork if it is not done correctly, and you may lose your filing fees. If you really want to file a pro se divorce, look for the rules for your state and see if you can find the forms online. You can find the Virginia forms at virginialegalaid.org. Make sure to answer no to the question about whether you or your spouse are in the military, or else the program will not work. If you are representing yourself in Virginia, make sure to bring your documents to a legal assistance attorney to review before you file them with the court.
The Expanded Legal Assistance Program, ELAP, may be an option in certain cases. This program allows one of our legal assistance attorneys to represent a service member spouse in an uncontested divorce. If the divorce is contested, ELAP is not an option. You must show the following in order to qualify for ELAP. Number 1, you are the service member spouse. Number 2, the divorce will be uncontested, which you can show by presenting a notarized separation agreement that both spouses have signed. Number 3, you must also show that hiring a civilian attorney would create a substantial financial hardship. There is a presumption that service members in the grade of E4 and below are eligible. You'll need to provide financial information such as your LES and a listing of all income, debts, and expenses. Talk to a legal assistance attorney to see if you should apply. If the Chief of Legal Assistance approves your application, you will not pay attorney's fees, but will pay the court filing fee, which runs between $80 and $90. Please note that we only handle cases in the areas immediately surrounding Fort Lee. We cannot go to Newport News, Arlington, or anywhere outside of our immediate area. Finally, you should know that this service is available based on our office's resources at any given time. Our office has informational handouts on separation and divorce. These handouts are available in the information kiosk in the reception area. If you need to speak with an attorney concerning family law matters, you can call the Client Services Division at 804-765-1500 to make an appointment. You can also come to our walk-in hours on Tuesdays and Thursdays at 1300.